Lord, my respectful submission is, my Lord, that issuing a mandamus with regard to a legislative discretionary function of a coordinate constitutional functionary would violate the theory of separation of powers. And in my submission, this separation of power is a part of basic structure. My Lord, I leave it at that. My Lord, now, my Lord, I come to, my Lord, page 808. As soon as possible. At the outset, my Lord, I make it clear. My constitutional interpretation, with whatever limited understanding I have, is that as soon as possible cannot mean endlessly. There is no doubt or dispute about it. For which, my Lord, and your Lordships very rightly, my Lord, prevented me from giving the empirical data. But since last 50 years, assent of 90% plus bills are given in 1 month. Even in case of state of Tamil Nadu, except these few disputed bills, the assents are given, Lord, at least we have the data from 2005, within 1 month. It cannot be, Lord, that the governor has a power to sit over the bill endlessly. That's not my respectful submission. Lord, the purpose by which the Constitution uses the expression as soon as possible is, my Lord, this. Lord, every bill has its own context-specific issues. Sometimes it might need, my Lord, consultation and collaborative exercise with the executive. Sometimes, and my Lord, your Lordships may, with my Lord's experience, longer experience both on this side and that side, would, my Lord, also appreciate this, my Lord. Sometimes, because of a popular public perception, despite knowing that this bill may ultimately harm the state, the legislature is required to pass it to calm down the situation. And there are instances, my Lord, I don't want to go into the facts, where the executive requests the governor that we have passed it, but you please hold your hands till the matter is cooled down. Sometimes the governor himself may feel that this is something so drastic which is taken because of peculiar fact situation. If I wait for 2 months, maybe the situation might change and I'll be able to persuade the government to either withdraw or to make some suitable modifications. Well, there are large number of such contingencies. And it is that, Lord, constitutional collaboration and consultative process which has worked successfully. Imposing 1 month and 3 months time limit would be self-destructing, apart from being not permissible under the Constitution. That leverage, that discretion shall have to be in the larger interest conferred. While saying that as soon as possible does not mean perennially sitting over the bill or sitting over it for 3 years or 4 years. There may be, my Lord, good reasons to wait for 6 months. They are in discussion. Whatever, my Lord, I don't want to multiply, my Lord, the situations or exigencies. But there can be, my Lord, a possibility that this straitjacket timeline, my Lord, may not be a permissible, my Lord, way of. And, my Lord, there are several bills which, by its very nature, is required to be assented to on the next day. Why even 1 month or 3 months? So that is, therefore, my Lord, the Constitution says as far as possible. As soon as, I'm sorry, not as far as possible, as soon as possible. It was a inadvertent error. As soon as possible. So while not taking, my Lord, an extreme position that perennially sit over it, but I'm saying that it depends upon the fact situation, and please leave it to the constitutional wisdom of a coordinate constitutional functionary, rather than binding him that you do it within 1 month, and if she doesn't do it, come to us. That may perhaps not be, my Lord, the constitutionally correct course of action, my Lord. And, my Lord, I have given the judgment, my Lord, they relied upon constitutional silence. That constitutional silence can be filled in. Lord, this is a conscious constitutional choice of words. Constitution is not silent. And even if it is silent, Lord, I'm not reading, my Lord, but this is not a constitutional silence. This is a conscious choice of words. and a conscious call to leave it to the discretion. I'm not reading the judgment. Number three, this is not a Vishakha situation where your lordships would thereafter supplement something. Even if there is a silence and silence is required to be cured or corrected, the remedy would be Article 368 for the Parliament to prescribe time limit with some manageable standards, with some condition or whatever, my lords. I have reservations about Telangana view and Punjab view. And another thing, he's a tribunal. He's a tribunal. My lord. Suppose some decision is to be taken, my lord. Suppose the governor is also a vice chancellor or chancellor. He is supposed to take a decision within 2 months. Or no time period is prescribed. Your lordships can issue a direction because he is acting in his executive capacity, purely administrative capacity. Therefore, my lord, wherever the Constitution has used some words or chosen not to use some words, it's a conscious constitutional choice. It's not, my lord, a silence which is required to be filled up by a judgment. So, my last submission. My lord, what now, my lord, after, my lord, if suppose, my lord, our submissions are find favor with your lordships, either fully, partly, whatever. The argument, which was again, my lord, a very extreme argument, was that you can do nothing about the Tamil Nadu view. I'm not on the judgment. Intra-party, the judgment is final. That's the law of the land and binds, my lord, us. I cannot argue contrary to it. But your lordships has the jurisdiction and power to declare that Tamil Nadu judgment is not the correct law. And that is what, my lord, as a last proposition, my lord, I wish to, my lord, submit. My lord, please come to page 816. My lord, I read it, my lord, but there are 2 or 3 paragraphs and I would wish to, my lord, reread it, my lord. Main emphasis, my lord, your lordship said, 816. Well, this is a 2G judgment, where your lordships would, my lord, remember, in the questions which were referred by the Honorable President, one of the question was whether this particular judgment of Justice so-and-so and so-and-so is a correct law. The court says intra-party we cannot go. My lord, that background in mind. Para 45. My lord, I'm making this submission with responsibility and understanding what I am making.
But is there a question framed to that regard? So will be only
Mr. Datar has said that you cannot touch the law laid down. Lord, what Mr. Sibbal did was, when he, only give me a minute. It's not, Lord, something, Lord, I am saying it with a sense of responsibility. He rightly objected at the right time. Lord, when he could not raise these objections, my lord, at the outset, when the preliminary hearing was going on, he said, look at this question, cannot be answered. Look at this question, cannot be answered, and re-raise preliminary objections. Mr. Datar specifically said, law laid down by Tamil Nadu judgment is the law of the land, and you cannot touch that law of the land, and I am entitled to respond to it, my lord. Please allow me, my lord, to read only 2 or 3 paragraphs of 2G judgment. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri judgment, which according to him prohibits this court from overruling a view expressed by it previously under Article 143(1). We are not persuaded to agree with the learned counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of the court, whereas in the subsequent sentence, he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these 2 situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draws a difference between the 2 by using the word when. Further, this court overrules the view of law after discussing the decision. My lord, kindly turn the page over. 817 and bold part. After the exercise of those limited options, the parties concerned have absolutely no relief with regard to the dispute. It is considered settled for eternity in the eyes of law. Lord, between Tamil Nadu and Union of India, and governor, for those bills, it has attained finality. Please see this. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced by the court of reaching the decision. Justice Sawant in so and so clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power. When he says, then, my lord, it is quoted. This is a judgment in a reference with a, while dealing with a contention that that judgment and the view expressed
So,
cannot be touched.
How
Yes,
should be applicable
it's
here
not just, my lord, as said, it's only a report. Your report, your lordships are not a reporting authority to the president. It was, my lord, unfortunate that such a word was even used. The honorable president has sought your lordship's constitutional interpretation, and your lordships are, my lord, giving the advice to the president. It's not just a report. And your lordship's inherent power, my lord, that's what the court says, can permit your lordships, my lord, to even overrule the view expressed while maintaining the decree intra partes. My lord, last at the foot, my lord,
In
the
any
highlight.
case, the judgment of view taken by two judges on law would not be binding on the constitution.
The argument was it is binding because yes,
that
yes,
judgment
I'm
will be
not on that. But argument of Mr. Datar was that that is a law and therefore it binds even the advisory jurisdiction of this court. And your lordships cannot touch even the view expressed. My lord, kindly see the last line, last highlighted part. In fact, the overruling of a principle of law is, my lord, please see, my lord, page 817, paragraph 48.2, the highlighted part. In fact, the overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. The argument was that if you overrule the view of law, you will be sitting in appeal over the two-judge bench judgment. Court says, no, it's not appellate jurisdiction. It's our inherent jurisdiction. This inherent power can be exercised as long as a previous decree vis-a-vis lists inter partes is not affected. For those bills, my lord, that is final. My lord, somebody can, my lord, take a remedy whether there is repugnancy, not repugnancy, etc. Your lordships would not go into it. But your lordships can say, and in my respectful submission and prayer, that please say that that's not the correct law which is laid down. My lord, last point, my lord. My lord, I have dealt with all, my lord, the submissions of my learned senior friends. My lord, only one submission was made by the intervener, my lord. I don't know, my lord, what was the purpose, but he relied upon Article 374 that federal court judgment is binding. I don't think, my lord, your lordships would be going into that because the federal court judgment is being binding or not. But there is a judgment of your lordship saying that federal court judgments are not binding to the Supreme Court of India. Direct judgment, quoting the very provision, my lord, which was relied upon by the intervener. I don't think, my lord, I can go, but kindly note, my lord, if your lordships are taking note of that, because he relied upon some federal court judgment and said that you cannot examine the reference, etc. And, my lord, this is 1991, volume 4, SCC 406 and paragraph 32,
1991.
1991, 4 SCC 406. It's a 3 honorable judges, Justice Kuldeep Singh. My lord, it's on record. 4584. My lord, I knew somebody would raise this issue. 4584. My lord, para 32 and the relevant at 4626. Para 32. Mr. Nariman raised this very argument, which was repelled. That for federal, why, my lord?
What is that?
My lord, it is Delhi Judicial Services Association versus State of Gujarat. Anyway, my lord, whatever. But it's not a point in consideration. Nobody has argued, my lord, at least the states have not. I am also not, my lord. 142 evolves, my lord, from the facts of each case, my lord. But that is fundamentally wrong. And if your lordship holds that it binds, that will be opening floodgates, my lord, because what happened in 1920 and what was the law laid down in 1920 start becoming binding. My lord, therefore, this question has arisen and is answered in the negative. My lord, I am immensely grateful, my lords. And, my lord, I must say, my lord, I have learnt a lot from all, my lord, Mr. Sibal, Mr. Gopal Subramaniam, Mr. Singhvi, Mr. Datar, everyone, my lord. It's an enriching experience from your lordship's query also, my lord. Every time my lords put a query, my lord, we researched, and my lord, that was an enriching experience. But I'm really thankful for my team, especially Kanu Agarwal. We are as good or as bad as, my lord, our team. My lord, I'm grateful to everyone.